Good afternoon. I am not Kelly Voss, president of the Washington Council of Lawyers. She is suffering with a stomach bug, so I am filling in. I am Nancy Lopez, the executive director of the Washington Council of Lawyers, and I am still rocking the red. I am honored to welcome you to this year's Summer Forum. On behalf of the Council, I want to start by thanking our co-sponsor for the event, the American Constitution Society. I also want to thank Georgetown Law and the Office of Public Interest and Community Service for hosting us today and helping to make this event a success. The Summer Forum is one of Washington Council of Lawyers' finest and earliest traditions. We've been hosting it since 1978. The goal today is the same as it was then, 30 years ago, to inspire each of you to be the kind of lawyer who works to bring our society closer to the ideals of liberty and justice for all. Today, we do not need to look much further than this stage for inspiration. We are thrilled that David Cole, the National Legal Director of the ACLU, is joining us to reflect on his experiences and the importance of public interest law in our society. We will hear more about David's accomplishments in a moment, but for now, I would simply like to express our gratitude and our excitement for the opportunity to hear from him today. I also want to thank Nicole Austin-Hillery, who will be leading the conversation with David. Nicole is a longtime Washington Council of Lawyers board member. In her day job, she is the executive director for U.S. programs at Human Rights Watch. In that role, Nicole leads the organization's efforts to advocate for human rights and to address rights violations in the U.S. immigration system, our criminal justice system, and in our national security policies. She's a busy lady. Previously, Nicole was the first director and counsel of the Brennan Center's Washington, D.C. office, which she opened in March 2008. In that role, Nicole oversaw the growth and development of the Brennan Center's advocacy, strategic communications, and policy development work in Washington. She also served as the Brennan Center's chief liaison to Congress and the White House. Nicole, thank you for being here with us today. Before we begin the program, I would like to take a moment to tell you about the Washington Council of Lawyers. Washington Council of Lawyers is D.C.'s only bar association solely devoted to the mission of advancing access to justice, pro bono service, and public interest law. Through events like this one, we strive to build and strengthen a community of lawyers from all sectors who are energized, mobilized, and prepared to pursue pro bono and public interest legal work. It is our great hope that many of the law students in the audience today will return to D.C. to practice law, and that you will actively use your legal talents to help poor and marginalized members of our society. And we stand ready to help you pursue those goals. If you are not already a member, I hope that you will consider joining our community by becoming one. You can sign up online or on your way out today. I also hope that you will join the conversation today. We are using the hashtag ALLCAPS. No. Our hashtag for today is SUMFO18, SUMFO18. And now I turn the stage over to Nicole Austin-Hillery.
Thank you, Nancy. I don't think this is on, but I have a loud voice, but I'm going to test it. It's not on. This is how much it's on. Let's make it on. I have to tell you all, I went to Carnegie Mellon undergrad, and for anybody who knows about Carnegie Mellon, which you all should, it's an amazing engineering and technical school. You would think some of that would have rubbed off, but it didn't. Thank you, Nancy.
All right.
There you go.
Sure. Yeah, that sounds like it.
This is why we become lawyers, so we don't have to figure these things out. David, welcome.
Thank you.
It is a pleasure to have you with us here today.
It's good to be back at Georgetown.
Yes, I have to tell you all, you know, David was a professor here at Georgetown and had been here for 25 years. So sitting with him in the hallway as we were just chatting and getting ready to come in to talk to you all, it was kind of like being next to a rock star. So people were very happy to see him back. So we're happy to have you with us today too, David. You know, the Summer Forum, we have a mix of people here in the audience. But one of the things that is always constant at the Summer Forum, and this is where I'd like to start our conversation, is to talk a little bit about why you became a public interest advocate. You know, I'm one of those weirdos who at age 13 knew she wanted to be a civil rights lawyer. If you look back in an old playbill from my junior high play, it says, Nicole, when she grows up, wants to be a civil rights lawyer. Yeah.
Wow.
And I still have it. It's hard to believe. So what led you to doing this kind of work?
So when I was 13, I wanted to be an Olympic swimmer. That didn't work out, so here I am. No, I actually kind of backed into it. I went to law school because I had nothing better to do. I liked being in college. People said going to law school was like could be like continuing a liberal arts education. And I wanted to be a writer, actually, and I thought, well, I can do freelance writing while I'm in law school. I did, actually. When I got into law school, I started working for the undergraduate newspaper. I was the only graduate person working for the undergraduate paper, and I took time off in law school because I thought, oh my God, I'm going to graduate. I'm going to have to fish or cut bait on whether I'm actually going to practice law. And so I interned at the Atlantic magazine for a semester, and then I had an internship lined up at the Nation for another semester. But you know, I learned very early on in law school that you always have to have a fallback position, right? So my first position was I'm going to be a writer. I wanted to be maybe a jazz critic or something like that. Again, you know, that was that Olympic swimmer, jazz critic.
You aim big, David.
Yeah. So, but you know, I learned you have to have a fallback position, you know, and so my fallback position was, well, if I want to practice law, I want to practice public interest law. I want to work for people who need assistance. I want to work for justice. I was raised by educators who were Catholic and kind of social activist Catholics, and so those were the values they taught me. You know, one, you know, work for others, and two, do things that you care about rather than things that are going to make you a lot of money. Because I mean, some people care about making a lot of money, sure. but you know, you're going to be spending your life doing whatever you choose to do. Make sure it's something you care about, and I cared about issues of justice. And so I worked at a lot of public interest places, both summers. I had 3 summers because I took time off in law schools, 3 different summer positions. Did a clinic, I did externships, and it really wasn't until the last one. You know, the first, I think I did 5 in all. The first 4, they were good, but they didn't dissuade me from my desire to become a jazz critic. And then, you know, my sort of, you know, inability to play a musical instrument might have dissuaded me, but that didn't dissuade me either. But then I went to work for the Center for Constitutional Rights in New York my last summer, and I was transformed. I absolutely loved it, and I called I was actually supposed to go to the Nation and intern for the fall, and I called the Nation and said, I'm sorry, I'm not going to show up, and I stayed at the center and worked there. I ended up working there for a year while I was finishing up my last semester at school, and then went back and practiced there. And I, you know, in retrospect, I don't regret a thing. I don't think I would have been a very good jazz critic, and you know, and I every day of my life I've felt privileged to be able to get up in the morning and think about fighting for causes that I believe in, and argue in courts for causes that I believe in, and work with clients who I care deeply about, and work with people who all have the same sort of mission-driven idea about work, and that is a tremendous privilege.
I love the stories about those moments when the light bulb just goes off.
Yeah.
And you realize, this is what I need to do. And I will tell you, David, there's a correlation between jazz and justice. There is.
Yeah,
but
yeah.
That's another forum for another discussion. So maybe Nancy, next year, note to file. We'll do that.
I think Sun Ra understood that. But,
yeah, I think you're right.
Yeah.
So David, you spent many years in academia. But tell me how you made the transition from academia to working for one of the nation's largest and most highly regarded public interest organizations.
So I taught here for 25 years, as Nicole said, but I continued to practice the entire time that I was teaching. So when I came from CCR to here, I kept my caseload, I kept my office, I was living in New York, I came here to teach Tuesday through Thursday and was there, the rest of the time. So I just kept doing constitutional litigation pro bono, usually with the Center for Constitutional Rights, sometimes with the ACLU, sometimes with both, sometimes with others. So I was very, I knew the ACLU, and we had worked together. The prior legal director of the ACLU was Steve Shapiro, who'd been in the job for 25 years, the same period of time I'd been here. So when he stepped down, I thought, oh, that'd be a great opportunity. And Anthony Romero, who's the executive director, who's really fantastic, came down to D.C. to urge me to apply, to consider applying for the job.
And remind us what time period this was.
So this was the spring, summer of 2016. So he came down, and think back to the spring, summer of 2016. It was a different world. And he came down and he said, David, I have an offer you can't refuse. You've been practicing constitutional law for 35 years under a conservative majority Supreme Court. Just think what it'd be like to lead the ACLU's legal department under a liberal majority Supreme Court. And I thought, wow, that'd be fantastic, right? So I signed on the bottom line and didn't put in a conditional clause, what if? I then applied for the job. I got the job, and that was announced in the summer of 2016. I didn't start till January of 2017 because I was finishing up teaching here at the law school and the like, and Anthony chose. But I got my lawyers at the ACLU to work on memos on how we could advance constitutional law in each of their special projects with a liberal Supreme Court, because we all knew we were going to have a liberal Supreme Court, and Anthony, I think, was so confident about all this that he scheduled an all-staff, national staff meeting. We have 500 people in the national staff for November 9th, 2016, at which I was going to be introduced as the new incoming legal director. So on the morning of November 9th, after a long night, on the night of November 8th, I got on the train, went up to New York, and that meeting was not about my starting. That meeting was about a new day. So the job changed remarkably. Sure. But it's in many ways it's a more challenging job, to be sure, but it's also, I think, a more important job. It's at times like this that groups like the ACLU and Human Rights Watch and the Brennan Center and so many other organizations are so needed, because you've got one-party control of the presidency, the Congress, the Supreme Court, the two-thirds of the state legislatures. Where are the checks going to come from? I think they come in these moments, especially from civil society. So I feel it's been a fantastic time to be fighting with the ACLU for civil liberties and civil rights against an unprecedented threat.
That's a great attitude, considering Anthony pulled the old bait and switch.
Yeah.
And I don't know what your favorite thing is, but he owes you a lot of those favorite things. A new car, something. Yeah. After November 8th, 2016, and you come into the job in January, tell us what that meant in terms of what your priorities were now going to be for the organization. Yeah. And maybe juxtapose that a little with, what the organization had always been known for. We all know generally that the Civil Liberties Union fights for civil liberties. Yeah. But what did that mean in terms of, what are the issue areas that you focused on then, and how did that change post-November 8th, 2016?
Yeah. So great question. I mean, we are an across-the-board civil liberties, civil rights organization. We do everything from religious freedom to capital punishment to LGBT equality to speech, privacy, and technology. We have it's a broad range, but we had a set of priorities before the election, and they were, if I can remember them now, because that was a different world. But they were at the time immigrants' rights, reproductive rights, LGBT equality, voting rights, reducing mass incarceration, and privacy in the digital age. And some of these were because they faced unprecedented threats. Immigrant rights faced unprecedented threats under Obama, and even more unprecedented threats under Trump. Some because we were sort of entering a new era, digital privacy. How do we retain and protect a sphere of privacy in the digital age, where we all are carrying around more private information, in our pockets than in our homes, and what are the consequences of that? Some are areas where we felt like we had real opportunities, like LGBT equality, that there's been a tremendous advances in that area, and we wanted to get it to the goal line of recognizing full equality, not just in limited spheres and limited spaces. So those were our programmatic emphases. But we are in some sense a defensive organization, right? We defend rights when they are most under attack, and so we have to be responsive to where the threats are. And under Trump, the principal threats, their threats are very broad, but in the civil liberties and civil rights areas, the principal threats that we've been really amping up to respond to are in the area of immigration, voting, because the Republican strategy is to suppress, seeing that the demographics of the country are changing and that votes are going in a different direction among young people and among people of color and the like. Their response is not to change their programs and policies to recognize the broader constituency, but to suppress votes. And so voting rights is a big area that we've grown substantially in. And reproductive freedom, because President Trump promised to overturn Roe versus Wade. He has freed up employers to deny contraceptive coverage to their employees. He's trying to turn the Title X family planning program, which is where poor people get birth control, turn it into an abstinence-only program. So those have been our primary sort of Trump response initiatives. But we continue with those other priorities. So our effort to reduce mass incarceration, 50-state strategy, began before Trump, is continuing after Trump, and there's an area where there's actually bipartisan agreement that the criminal justice system is too big, too broken, needs to be brought reformed, and so we're working in a coalition that is, I think, the only coalition in the United States funded simultaneously by the Koch brothers and George Soros.
You're right about that. Now, one of the things that I'm finding interesting right now is, and particularly even for us at Human Rights Watch, and certainly when I was at the Brennan Center, is how do you simultaneously stay sharp in terms of being a responsive organization, but also work on forward-looking thinking and strategizing, because we all know that duality is really important. None of us at these organizations have the luxury of simply responding to actions without thinking about how do we move the ball forward. So tell us how you're doing that, and tell us how you are engaging a broader coalition in doing that, members of the public. Because we know so many people, individual people, who before 2016, before that election, would say, I was not a person who was interested in political issues. I was not a person who was particularly interested in community organizing. But after that, they all said, we want to get involved. How do we do that? So to talk to us about how you're handling, those dual responsibilities.
So one thing we did, 2 days after President Trump was elected, we took out a full-page ad in the Washington Post and the New York Times saying, essentially, we'll see you in court. And we said, if you put in place a number of the programs that you promised as a candidate that we think are unconstitutional, we'll see you in court. And we did. We have. We brought the first lawsuit against the Muslim ban within about 12 hours of the Muslim ban being issued. We filed a lawsuit in Eastern District of New York, in Brooklyn. on Friday night, Saturday morning, and Saturday night got the first injunction against that. And we've continued to challenge the Muslim ban all the way through. It's our case that in which the Fourth Circuit held that the Muslim ban, in its third iteration, also violates the Establishment Clause. We've challenged the family separation policy now, where there's ripping children from their mothers in order to deter people from coming to this country, unconscionable tactic, which we have challenged. We've challenged DACA revocations. We've challenged the transgender military ban. We challenged the detention of an enemy combatant without charges and for months on end and without access to a lawyer, an American citizen who's being held in Iraq as an enemy combatant. We challenged turning Title X family planning into an abstinence-only program, which is not what it was designed to do. We challenged the order that allows employers to deny contraceptive access to their female employees. We challenged the Voter Integrity Commission, which was an attempt to basically create a record for voter suppression. So we've done that, and for the most part, in the lower courts anyway, we've been successful. The courts have enjoined the transgender military ban, the military ban, revocation of DACA. They protected the enemy combatant, et cetera, et cetera, et cetera. So that's been fairly successful to date, but that's nowhere near enough. And as you said, many people have stood up. And I think if we're saved, we're not going to be saved by the courts. We're going to be saved by the people. But I think the positive part of this Trump era is how many citizens have in fact stood up and said, I want to get engaged. I mean, the fact that in basically a year and a half, we've had the Women's March, which was just a remarkable, unprecedented outpouring across the country. We had the airport demonstrations after the Muslim ban, right, which I think are remarkable for two reasons. One, people were going out to demonstrate not for their own rights, but for the rights of others, right? He was targeting foreign nationals and Muslim foreign nationals, and yet American citizens came out. And the second thing that's amazing is that they went out to airports. I mean, I don't know about you, but the last place I want to be is, unless I have to be going somewhere, is an airport.
Exactly.
And yet people came out in thousands, and they even went to airports that didn't have any international travelers. They just because they want, they want to be out there.
Which was just symbolic.
Yeah. But then you've had the town halls about Obama saving Obamacare. You've had the Me Too movement, which would not have happened were not for the abuser in chief in the White House. And the Parkland. I mean, there have been many mass shootings at high schools. Only one of them sparked a national movement. And all of that, I think, is a reflection of this engagement on the part of citizens who see a threat and are standing up. At the ACLU, we went from, I sometimes say, sometimes people say, how's it going at the ACLU? I said, well, I've been there since January. Before I started working at the ACLU, we had 400,000 members. Now we have 1.8 million members.
Wow.
Pretty good, right?
Yes.
I'm not sure I can take credit for that.
Go ahead, David.
But in view of those, 1.4 million new members that we have, and they don't just want to carry a card, they want to do something. So we've launched a grassroots mobilization effort for the first time, really, since the ACLU's earliest decades, when it really was a grassroots movement. We have this grassroots movement arm called People Power. Sounds like it comes from the 60s, but it's, no, it's the 21st century. But it's basically, the idea is that, the ultimate power in democracy lies in the people as citizens engaged. And so we encourage our supporters and our members to come together in small groups and take local action in defense of civil rights and civil liberties. And I think that's key, because if we can get people engaged, if we can get people seeing themselves as citizens, if they act locally, they can often make a difference. They can see that that difference works, and then they get more engaged. And you build, that's the way you build hope. And ultimately, right, what we want is for people to, as we now say it, vote like your civil liberties depend on it. In the 2016, in the 2018 midterms, and in 2020, because you know, the courts are critical to protecting constitutional rights and civil rights, but ultimately we need democratic support for these rights. And I think, to me, the silver lining here is that we have the opportunity to build, and I don't mean we, the ACLU, I mean we, people who care about civil rights, civil liberties, and equal justice for all, have the opportunity to build a movement that is cross-sectional and that will, I think, transform this country going forward. And so I'm hopeful that we could look back, 10 years from now on this period and think, wow, that was a dark period, but it inspired citizens to stand up and fight for what they believe in, and turn the corner. And I think that's a real possibility. It's also a possibility that we are a fascist regime in 10 years. But but to me, I would bet on the first rather than the latter. And more importantly, it's ultimately up to us. Mm-hmm. It won't become an authoritarian regime if we don't allow it to become an authoritarian regime. And I see a lot of Americans who are not going to allow that to happen.
Well, David, you make an interesting point when you talk about the concept of movement building. Talk about that a little bit in terms of the role of the lawyer. Because a lot of people don't necessarily think of lawyers as people who build movements, even though history has shown us that lawyers like Charles Hamilton Houston, who was the person who created and structured the entire Brown v. Board litigation strategy, certainly created a movement to try to end discrimination in the United States. Talk about the role of the lawyer as a movement builder, because I don't know if people would necessarily think, oh, if I get out of law school and go to the ACLU, that I'm going to be a person who's helping to build movements.
Yeah. So look, I think as a lawyer you can do all kinds of things. You could even be a jazz critic as a lawyer. But so you could certainly build movements. I don't think you're going to build a movement by filing a lawsuit, right? But a lawsuit can be part of a campaign to build a movement. And I think people increasingly understand that lawsuits will not succeed unless there is support and a movement around them. So I wrote a book in 2016 called Engines of Liberty: The Power of Citizen Activists to Make Constitutional Law, and it basically looked at three successful campaigns for civil liberties, civil rights, individual rights in the last 30 years. The marriage equality, the fight for the individual right to bear arms, which, whether you support it or not, it's pretty remarkable what the NRA did, how it achieved that. And then the fight for human rights in the war on terror under George Bush. And the argument of the book basically was, we spend a lot of time, writing about lawyers, reading Supreme Court cases, teaching students to be appellate advocates. That's what law school really, mostly is about. But in fact, that's not how law develops. Marriage equality was not won because Don Verrilli and Mary Bonato made brilliant arguments in the Supreme Court, even if they did. It was won because groups committed to gay rights fought over 30 years in a variety of different forums, mostly outside of the federal courts altogether, to change the culture so that an argument that was frivolous 30, 40 years ago was a winner in 2015. And the same thing with the NRA and the individual right to bear arms. Chief Justice Warren Burger, a conservative Republican, said in 1990 that the notion that there's an individual right to bear arms was one of the greatest frauds perpetrated on the American people in his lifetime. 18 years later, the Supreme Court recognized it as a constitutional right. How did that happen? It wasn't because some lawyer, Alan Gura, who's actually a Georgetown grad, made a great argument in the Supreme Court. He made a good argument in the Supreme Court, but it was because the NRA ceded the ground so that the court would actually rule that way. So how'd they do that? They just like the marriage equality folks, they went to the states. They started in their most friendly states. They got gun rights friendly amendments and statutes enacted, first in Florida, and then they moved, to Alabama, and then around the country. And so by the time it got to the Supreme Court in 2008, virtually every state in the Union had recognized an individual right to bear arms under their state constitution or their state law, making it not that big a step for the Supreme Court to do so. They got academics to do research and write articles about how there was actually some historical support for the notion of an individual right to bear arms, which before had been pilloried as, of course there's no historical support. By the time it got to the Supreme Court, professors like Larry Tribe were saying, yeah, there's some support for the notion that there's an individual right. Akil Amar, liberal professors, saying there is some support. They got Congress to say there's an individual right to bear arms in a couple of statutes, and they got the executive branch to say, when Bush was elected, in part through very strong support from the NRA, John Ashcroft became the Attorney General. They immediately wrote to John Ashcroft and said, do you think there's an individual right to bear arms? And the Justice Department for 100 years had said what the courts said, which is there isn't an individual right to bear arms. But John Ashcroft said, longtime NRA member, of course there's an individual right to bear arms. And he got the Justice Department to reverse their 100-year position and write a 100-page memo. To reverse a 100-year position, you need a 100-page memo. That's the rule, by the Office of Legal Counsel. And so by the time the case came to the Supreme Court in 2008, they had already gotten the states, the Academy, Congress, and the executive branch behind the notion of an individual right to bear arms. Well, then it's not, so the work has to be, if we want to think about how to be effective in defending liberty, you have to think about movements, about people, not just about arguments in court. And so that's what we do.
And I hope no one out here, for you law students, are scared away either by the notion of the 100-page memo or the notion that you might have to write a brief and get ready to file a complaint in 12 hours.
Yeah.
Don't let any of that scare you. David, talk a little bit about how, first of all, I love your attitude. I love that when people ask you, how's it going, that you have really positive, impactful things to say about the work that's being done right now. But how do you pivot at those moments when you get a decision that doesn't go in your favor, like the Supreme Court decision earlier this week dealing with the Ohio voter purge issue?
Yeah. So look, I've had my share of losses in the Supreme Court. We were counsel in the Houston case, the voter purge case, and very, very disappointing loss. I argued Masterpiece Cake Shop, which we lost in a very narrow way, but I think I probably won the war in a broader way because the court said some very, very strong things in getting to a very narrow result. You have to you build off of your losses as well as off of your victories. When you have a victory, you say, okay, here's a stepping stone that we can now rely on to make an argument for the next incremental step. And I think, I think social change is virtually always incremental. It comes in small steps. I tell my students, you came to law school, that means you're not a revolutionary. Right? Particularly in law, things change, and they're like, wait a minute, I came to law school to be a revolutionary. No, wrong school. So
which school does one go to become a revolutionary?
Sociology, I don't know. Education, there you go. No, and so if you have a victory, it's almost always going to be incremental, and then you have to build on it, right? So Windsor was an incremental victory, which they built on to Obergefell. But you also build off of your losses. So if you think of the marriage equality movement, 1996 was when President Clinton signed was it 96, I think? I might be wrong on my year. But anyway, when President Clinton signed the Defense of Marriage Act, an anti-marriage equality bill. But that, so that was a huge loss, triggered by some partial victory in Hawaii. But the marriage equality movement didn't give up. You know, they said, okay, we're not going to win this in Congress. Let's go to the states, and you know, and let's go to the states that are most sympathetic to us, or let's go to corporations that are sympathetic to us, like universities and the like, and get things like domestic partnership benefits recognized. And we're working to overturn the Defense of Marriage Act, but we're going to do it in this incremental way. And the same thing when Prop 8 was passed in California after, you know, this was a huge loss for the marriage equality movement, right? The California Supreme Court says marriage equality is required by the California Constitution, 2007. There's a movement to overturn that on the 2008 ballot in California, one of the most liberal states in the country, in the year that Barack Obama is elected, and they lose on Prop 8. That is, the marriage equality folks lose on Prop 8. Devastating loss. Spent $40 million and lost on Prop 8. Did they give up? No. They studied, you know, how they lost, why they lost. They transformed their messaging in subtle but really important ways, and redoubled their efforts. And again, at the state level, and the next set of referenda, they won, and ultimately set the ground for winning in the Supreme Court. So, you know, I think the Husted case is a terrible decision. It basically says that states can knock people off the voter rolls if they fail to vote, which is your constitutional right not to vote, right? You don't have to vote. And if they fail to respond to a card that they get in the mail. There's probably also a constitutional right to refuse to respond to a card that you get in the mail. But it's sort of irrelevant because nobody responds to cards that they get in the mail anymore, right? Who even, you know, gets mail anymore? And the court held that on a 5-4 decision, the Republican justices, 5 Republican justices voting, this is perfectly permissible to purge people. Why in the world we would want to be purging people from the voter rolls simply because they failed to vote and failed to return a card? Where, as Ohio knew, you know, many of those people remained, most of those people remained in Ohio, eligible to vote. And so I think you need to educate. Our voting rights director has an op-ed in today's Times on this very subject, and then you need to push people for legislative reform. So we're using people power. I mentioned people power. Right now, our campaign on people power is a let people vote campaign with a different set of things for people in each state in the union, developed by our folks in conjunction with the ACLU's affiliates. You know, we have affiliates in every state, and so we have people on the ground in every state. What can you do in California to expand access to the vote? What can you do in Alabama to expand access to the vote? Those are different questions, but in each place you can do things to expand access to the vote. So we have to respond politically where we lose in the courts.
I think that's a great framework for how we move forward. I'm going to borrow some of that too, David, because I get that question all the time.
I'm sure you do.
Know, how do you do this work?
Yeah.
How do you survive? How do you still have a smile on your face?
Yeah.
Which I always do. I see the bell is about to toll for us, but so here's my last question for you. We know that in the country right now, we are dealing with all kinds of issues around race and class and economics. And your organization is one that is known historically for paving the way for people to exercise their rights regardless of their viewpoints. How do we, and if you can answer this question, David, you'll solve all the world's problems. But start us thinking about how we move in the right direction on this. How do we, at this moment, given all that we've gone through since the 2016 election, and given that we know historically the tide will change, that's just what history has shown us. We have had other moments similar to this throughout history, particularly after some gains where there's been a backlash. But how do we as a nation moving forward, where we know we are going to be a nation that is made up of a majority of people of color very soon, where we are becoming even more diverse, especially if we get things right on immigration policy, how do we bridge the gaps between all of these groups and people who may think differently, who have different economic levels, who live in different places. How do we stop being a nation where it's blue on both coasts and then something different in the middle? How do we work together?
Well, I definitely can't answer that question. But I guess I think we can do our small parts, right? And I think the Bill of Rights is something that does unite us, and that and in particular unites us because they are rights for every human being in the United States. They are not rights for liberals. They are not rights for conservatives. They're not rights for corporations. They're not rights for immigrants. They're rights for all. And so I actually think the First Amendment work that we do, even though it's often uncomfortable, representing the Nazis marching in Skokie, or representing the man seeking the permit in Charlottesville, it's painful work, but I think it's actually really important work, because what it demonstrates is that the First Amendment, which I think is the core right, it is the right that makes all the other rights possible, because if you believe that at the end of the day, as Learned Hand said, liberty lies in the hearts of men and women, and when it dies there, no court, no constitution can save it. If you believe that ultimately it's us who are the guardians of liberty, right? How do we make that happen? We make that happen through the First Amendment, through speaking, right? Through advocating for justice, through association, the right of association, joining together in organizations like Human Rights Watch and the ACLU, the Washington Council on Law, to fight for justice for those who don't have it. Through the press, free press, also protected in the First Amendment. In many instances, through religion. Religions, can have commitments to norms that are, against the majority, whether they, be abolitionist or, in favor of the work the Unitarians did in favor of justice for gay and LGBT folks here in the district. All of that is protected by the First Amendment, and it is a right. It is not a right of progressives. It's not a right of liberals. It's a right of everybody, and because it's a right of everybody, we can all use it, but it's on us to use it, and it's critical that we ensure that it is available to all if we're going to be able to make it available to those least, those who need it most. And I think those who need it most are those who are marginalized, those who are dissidents, those whose views are not reflected by the powerful and the majority. Because if your views are reflected by the powerful and the majority, you don't really need the First Amendment. You need the First Amendment if you're sort of on the outside claiming justice. So that's how I would say. We are a studiously nonpartisan organization. We work with conservatives and liberals. What we're partisan about is the Bill of Rights, and the hope is that, and I think that's the hope of the Constitution. Never in this country have people agreed about everything. There was tremendous division at the founding of this country, but the idea was, at least let's come together with some set of higher ideals that identify certain principles that, even though we disagree about a whole heck of a lot, we can agree about these things, and then we can fight about what they mean through a, somewhat civilized process of law.
David, I think we just heard the preface to your next book. Thought that was great. Thank you so much.
Thank you. Thank you. Thank you. Thank you.
I may have to invite David to my house, and some of you too, because I want to keep this conversation going. So we'll let you know about that.
I'll accept.
Okay, great.
Are you inviting all of us, Nicole?
Everybody else?
I may. My neighbors may not be happy, but we'll figure it out.
Thank you very much for the remarkable, inspiring conversations. The work that we do as lawyers is not always revolutionary, but it is very, very important, and it's so nice to hear all the ways that happens. In a moment, I'm going to dismiss all of you to pick up a box lunch and a drink and head to one of our breakout panels. The panels are listed in your program, and what you'll find there are experienced practitioners who will tell you about their passion for their pro bono or public interest careers, how you can do work in that area, and all the different opportunities there that are available to you. I encourage you to use social media to share the conversations that are going on in those breakout rooms. You can see on the front, you can like us on Facebook, follow us on Twitter. We're on Instagram and Snapchat, and again, the hashtag is there, the SUMFO18. We'd love to spark a conversation that goes across from room to room, because we know each of you can only be in one place at one time. The places that you're going are, if you're interested in civil rights and civil liberties, that's on the second floor of this building in room 201. Criminal law and death penalty is in room 140. Immigration and human rights is in 141. Poverty law is in room 109. Transactional and non-litigation practice is in room 110. And then the ethics, accountability, and transparency, suing the federal government, is in a non-transparent room, 156, which is a little bit trickier to find, and there are people out there to direct you toward that room. You'll find when you go out that there is food on both sides, so you can filter out and head down that line and head to where you're going next. So then, thank you all for being here today, and join me in thanking David and Nicole for a fantastic conversation.
Close that up. That's good.
I'm going to leave the computer on.